Okay.
No, like, clip to your belt.
Oh, I don't have a belt, so I have to hold it the entire time.
Oh. Only a little more towards you.
Test, test, test. Thank you. All right. All festive. Well, it's that season.
Introduce myself. I'm Dawn McCartney.
We are very grateful. Good afternoon, everybody. Did y'all have a wonderful Thanksgiving? Yeah, I'm glad. No flooding, right? I have snacks up here so nobody will pass out from hunger. You could have an overdose on chocolate if you wanted. How many of you are new to the office? Yay! Are you new as a realtor too? Wow. I remember those days. Gosh, I'm sure we all did. We got our license and then we go, how do I do this? Why do I do this? Yeah, there's a lot of that. So you join the club. I wish I could help you with that, but I have no hand strength. Yes, sir, over there. Handouts are over there. Isn't that horrible? You'd starve to death before you could get into it. Oh. Yes, it's right there. And your handouts are over there. John, can you shut that door? Thank you. Okay, we're going to get going so that everybody can get on their way. Again, welcome to everybody who's new here, and I hope you did have a wonderful Thanksgiving. What we're going to talk about this week, well today, this month, was last month we talked about issues where agents have had issues that have made them reach into their pocket and give money to make everything work out. Today we're going to talk about the listing and the situations that listing agents have been dealt with when one of their sellers is not very happy with things have gone and those types of things. And for those of you that are new to real estate, show me how many are new in the last year. Listings are hard. Most of the time in our production, we start with buyers, don't we? Everybody does, it seems. But listings are more difficult because you are expected to what? Know something. You're expected to understand things, have a history, have a knowledge of things. So right away, the listing is already putting you in a position of, you're the expert. You ought to know all this. Why are you asking me, kind of thing. So again, it's because to be a listing agent, it requires you, oh, there's a piece of candy on the floor. Uh-oh. Just don't want anybody to jump on it and smash it. So listing agents are already dealt with needing to know certain things in order to represent sellers in the sale of their property. So what we're going to talk today about are different areas that have caused some issues. And then we're going to talk about some forms that we might use in the course of the transaction. We're going to talk about just the basic forms. And I'm talking about for every listing, there's just some things you better have in your arsenal, even if they're not on a checklist. You know what I'm saying? We have lots of things we do in the course of our transactions that aren't on a checklist, okay? So we want to make sure everybody understands why they're there and what they need to do. Then we're going to talk about, oh, thank you. There's the microphone. If anybody wants to talk, they're going to have to speak through the microphone so everybody can hear at home. Thank you very much. I appreciate that for setting up. The other thing is we're going to talk about some tips, some things you better cover on every listing presentation. Otherwise, it could be a situation that might not be very clear to the other party, okay? We do this day in and day out, so see, we don't have a lot of questions, do we? But we're assuming they have a base of knowledge, sellers do. It's the same the way we are with buyers sometimes. But with buyers, we're so used to telling them and advising them all these things. We don't tend to do that kind of presentation with our sellers, and we need to make sure we cover those things. Talk about disclosures. Well, after Hurricane Harvey, there's a whole new script in town. I'm going to tell you that that one natural disaster has literally turned fully disclosing everything on its ear. And what I mean by that, we had a situation where a seller said there had been flooding in the property. Okay, buyers went under contract. Buyers found out it was 6 feet, not 2 inches. As the listing agent had said, oh, they just had a couple of inches. Well, 6 feet is not a couple of inches. And so we've had lots of issues. In other words, sellers aren't going to be able to get away with saying Hurricane Harvey. I don't know. I still see Hurricane Ike on disclosures, right? That was from a long time ago. Well, nobody gets to just put a hurricane. They're going to have to be really exact about the condition of their property, how much water was in there, how long it was in there, all the different things. In other words, it's going to be quite involved. Now, if they are some of the fortunate ones that had no flooding, it's not going to be an issue. But for those that did have flooding, they have to be really, really good about full disclosure and detailed disclosure. We're going to talk about multiple offers because I find that listing agents tend to mishandle this the most. And nobody will forgive a listing agent for mishandling multiple offer situation. And so we'll talk about an addendum that we created specifically for that when we were back in the height of our multiple offer era. And we're in it again, believe it or not. And so I don't think it's going to go away. I just want to make sure you cover the points with the seller so the seller absolutely understands the process that you're going to follow, because we're not going to deviate from that. Otherwise, you could be subject to some issues. Earnest money disputes. Yes, we are still having them. And so we're going to touch upon what you really need to tell a seller, even before they get a contract, about earnest money. We have more issues with it, and they always look to you as the agent to solve it. And if it was up to us, we'd solve everything, wouldn't we? We'd have no problem making a decision, but it's not us in that process. There's other parties. And then our listings are still being hijacked. And what I mean by that is you're going to ask the sellers to kind of do a little bit on their own monitoring for you so that you don't have to sit in front of a computer every day and pull up and see if somebody has hijacked your listing. You really need to encourage them to help you in that process. Because the sooner somebody finds out about it, the sooner you can contact the provider to have it removed, and the happier, hopefully, everybody will be. The other thing I'm going to comment about, just from everybody working with any sellers right now, please advise your sellers to never open the door to anybody to see the property unless they have a previous appointment, okay? This is the time of year when things like that happen. And, you know, they just need to be told, again, to be safe. Don't ever, if they're outside in the yard putting up their decorations and a really nice realtor drives by with their clients in the car and she rolls or he rolls down the window and says, how long has it been on the market? Can we see it? They can't even do that. Do you know what I'm saying? We have a lot of instances where that has happened during this time of year, as well as in the springtime. People are outside more of their properties doing something, and lo and behold, somebody drives by and says, oh, when did you put it on the market? Remind your sellers that they don't have any conversation about their property with anyone that comes by like that. They always need to do what? Tell them to call their agent, to call your agent, or if they don't have an agent, to certainly call their listing agent. Last year, about this time, we had a horrible instance where UPS was, quote, making a delivery to a property, and they were not UPS. And they went in and they nearly killed the father and husband with a baseball bat. It was right over by the Galleria. And fortunately, the wife and the children got a safe room. They have a safe room in their home. And it's a miracle he survived. But it was that same kind of thing. You kind of let your guard down when somebody says, I'm here to deliver a package. And that's what your sellers need to know. Don't ever let anybody into this property. Most of the time, we don't really want sellers to be there, do we, when the showings are going on? How many think it's a good idea to have sellers at their property at showings? Yeah, I know. We all know that sometimes you can't avoid it. But I just want you to go out there to all your listings just to do a blanket thing saying, wishing you happy holidays, and please remember. And that might go for packages, too. You could probably drop something like that as well. Okay, let's just talk about some basic documents and why we have them. Okay, number one is the information about brokerage services, the IABS as we call it. Okay, Trek just revised all their advertising rules, and they approved them. And it was the first time in history that Trek changed the entire provision for advertising so that they can come after you even though they don't have it. So because of that, they're going to be looking at all of your advertising, and especially in the information about brokerage services, making sure it's always complete when you, yes? Yes, Trek changed the advertising rules. Most of the time, Trek only investigates complaints. Oh, no, now they have the right to come after you. Yeah, they're going to be looking at all your websites. They're going to make sure that all your information about brokerage services is totally complete, not blank. The consumer protection notices there, other things. But the information about brokerage services is one of those documents now that years ago it used to be blank, and all we did is ask our clients or our prospects to sign and date, and that is no longer the case. Everything has to be completed. It has to be accurate information. You can't leave an email blank or a phone number blank. They want totally completed information. The KWR warning notice. Well, I'm going to tell you that as an agent, I would give that at the same time I give information about brokerage services, even to customers. And the reason for that is cyber theft is not going to go away. It's only getting more clever and more sophisticated. 5 or 6 years ago, it was really obvious if you got an email, it looked fake. Well, even the title companies are now putting at the very bottom of all of theirs because they have all been hit with this. And so what you need to make sure is that everybody knows that you are not going to participate in any wire notices. They'll never get a wire notice from you ever, and that's what that disclosure is all about. It started because a title company got hacked, and through the title company, they got to a listing agent. And the hackers said to the title company, wire the proceeds to this account. And the person at the title, it was an attorney fee office, actually did it without verifying, and one of the sellers had already gotten their proceeds in the form of a check. So see, it didn't make any sense, but people are not, they have to be warned by you that you're not going to give wiring instructions or participate in that, so it keeps you totally out of the loop. Unfortunately, we've had several agents sued, and they were personally sued because Keller Williams didn't invite the hacker into their email and that. The agent did. And they lie in wait until they hear keywords, and this keyword was wiring. So they know you're out there doing business and in production, so be very, very careful, but always give that notice. I rank that up there where Trek requires the information about brokerage services. I don't want you to be held liable. Yes? The wire roaring notice would tell them that you'll never, ever ask them or give them wiring instructions. So the hackers went in there and used the agent's email address to get that individual to wire to a bogus account, acting like they were the agent. That's how it happened. On the two instances that we've had where there's been a settlement quite significant that the agent had to pay, they clicked on a link that came from lead generators from HR. And, of course, the hackers got in and just waited until something came up about wiring instructions. So, again, they do that. They're getting more clever, and they're not going to go away. It's a big, huge concern. So I don't click on any link. If you send me an attachment, I will never look at it. I will go into Dotloop and find it, but I will never click on any link ever again sent to me because of what I've witnessed, what's happened to the agents. And I'm not even in production anymore. But you just have to be careful and smart. We stay clear of it. Even title companies, as I said, are always putting the disclaimer at the very bottom now, notifying them. And the sad part about it, one of these hackers got really sophisticated and said, please call us to verify this to make sure that this is a genuine instruction. And, of course, the hacker answered the phone and said, yeah. So it's crazy what's going on. We need to better protect ourselves. And so this notice is really important to have it verified that you got them to sign it and acknowledge it. On the listing agreement, of course, we don't list properties in MLS unless we have what? A written listing agreement. We got some agents who think they can do it without one, but there is no way. Not even if you were representing another agent, that the listing agent has to have in writing a listing agreement. There's no other way. HAR requires that, and we do too as a brokerage. Plus the Code of Ethics say that all our agreements are in writing. We don't do anything without that. The seller's disclosures. You know, the seller's disclosure, as I said, is a 5-page document. It's brand new. They revised it as of 9/1/2017. So all listing agents need to use the current form only. Trek and TAR both said that, you know, any use of the old form after 9/1 is a violation. So as sellers, they should have completed one. If you have listings where you don't have a contract yet, get with your sellers and get them the revised form so that they can update it. Quite frankly, after Hurricane Harvey, no listing agent could use the same seller's disclosure. The sellers would have had to update it based upon that natural disaster. That's just common sense. And a lot of buyer's agents knew that. They were very careful about warning their buyers about signing a document that was pre-Harvey, and it was after Harvey. Remember, the lead-based paint addendum is a part of our seller's disclosure, but more importantly, it's a part of our contracts. So as agents, listing agents, you give it to the other party. The seller has to give the lead-based paint pamphlet, but when you get it back, you need to check and make sure they did mark their boxes, because otherwise you're going to have an incomplete form attached to the contract. And it's dangerous for both of the brokerages. I work for a broker that HUD came in and opened up every contract file that had a lead-based paint addendum that was subject to it. And they got fined on every transaction that did not have every box marked, and that they couldn't prove where the pamphlet had been delivered. As listing agents, how do we prove delivery? we send them an email usually with an attachment. That's how we can prove we delivered it. And especially if it's an email address that they've been using and we've been communicating with them. We can prove we delivered it. It's going to be hard-pressed for them to say they didn't get it, okay? A lot of times in .loop, when we share documents, we can see in the activity log that the other party viewed it and maybe shared it or signed it. So we have a good log of that. But since it's a part of the contract, we can't leave that to happen. It has to be done right and it has to be attached at the time of execution. The municipal utility districts, we have levy improvement districts, we have lots of different districts that have a taxing authority that the seller is obligated to disclose certain things. HAR created a nice form. They combined 3 separate forms into one. That was clever, wasn't it, finally? And so everybody still doesn't know how the municipal utility district is formed. Is it a part of the city wholly, or is it part of ETJ, and all this kind of stuff. Well, my concern for you as agents, listing agents, is that you disclose. And it's not your job to disclose. The seller is required to disclose and sign it and date it. And when the listing agent says, I'll fill it out, it's your disclosure. See, that's dangerous. A lot of the utility districts will charge a fee to your sellers to provide the most current form, and it might be on their own form, but it's going to cover all of the requirements by law. And the prices have been like $10 or $15. Well, I think that would be much safer if your sellers don't know it, to pay for it and get it done versus you, the agent, completing it. Because if it's wrong, you're going to be in trouble. Those forms, in the statute in the state of Texas, it says that if the seller fails to deliver by closing, there's a built-in fine. And TAR wrote an article several years ago about the first listing agent that got in trouble over that. And the seller went after the listing agent because their job was to make sure that that disclosure was provided to the prospective purchaser. And that is what we know. It's not our job to fill it out, but to deliver it based on what the seller was required to by law. And, you know, everybody's fine. They go to closing and say, oh, don't worry about it. And then something came up, and they found out that they had an issue. They could go back on the seller. And so, as I said, our advice and warning to you is that don't you complete it, otherwise it'll become your disclosure, and that's not a good thing for us. We're agents. We're not the owners of the property. Yes, ma'am?
How much is the fine? Do you have any idea how much the fine is?
I think the fine in the statute is $1,500, but it can go up from there.
And remind them what the fine is for the lead-based paint.
$12,000. And we had a lawsuit, and the buyer agent failed to get their buyers to mark one of the boxes. You know how C&D, they have to mark one of the boxes, and the buyer's agent failed to get that done, and that cost us $25,000. That's how I know that's a $100,000 form, because the seller completes 2 boxes, and the buyer gets to complete 2 boxes. And it was something we could kind of laugh about afterwards, but it really came down to that was what they charged. That's what the buyer got from the buyer agent, because they failed to properly advise them, make sure that they notate what they did get and receive. What's interesting is I've had a lot of listing agents over the years that like to fight about that. They go, well, why do I have to give the lead-based paint? I said, because it says the seller is required by law to do it. And sellers hire listing agents to what? To deliver, right? That's what we do. We deliver. We don't create them. And he used to argue and argue, and it's right there on the form. You can read it. I'm not making this up. This is a federal mandate. The brokers are warned that they better do it and help their clients uphold the law. It's that last thing right before the parties sign. So that's why it's real important to make sure all those things are completed properly and all the disclosures are done. The CMA, comparative market analysis, right? We give opinion of what? Price. We don't give value. We are value, but we don't give opinion of value, okay? We give opinion of price. Well, Trek at their meeting this month they modified it. And a few years ago, I had to create a form because the language changed. Statutorily, you had to have certain language saying you're not an appraiser, you didn't use the Uniform Code of Standards and that. Well, they've added another one. I guess it's just not clear to consumers, and so they're continually trying to provide a notice so that buyers and sellers will know the role you play in providing price opinion. Okay, and so we'll have that updated next month too, so that we can all start complying with the new TREC requirements. Notice I have something highlighted in yellow, and it says signed seller's net sheet for list price. How many of you have done a net sheet? That's what it's called. Yeah. Well, you're going to learn to do them and do them well. They're an estimated net sheet. In other words, it's telling the seller at time of listing, I'm listing your house for $100,000. Here are your estimated costs. I'm going to talk to you a little bit more about this. If everybody can pull up the seller's net sheet. I just printed one from the T8R form. Everybody's got that form? That was one of the handouts. Huh?
They're over there.
There should be some there. Yes, ma'am. Okay. Again, T8R presented this to us. There are great net sheets available, estimated closing costs and stuff, on a lot of the title companies' websites. A lot of the agents say they like Chicago Title. Some of them like Fidelity. Who do you use, Betty? Which, Alamo?
This is in MLS. You just hit on it.
Mm-hmm. Yeah.
I use this form.
Yeah. The TAR form is automatic. I am going to tell you, here's some tips that I want you to really, really go over and have on your net sheet. If you don't use the TAR form, whichever one you're using. If you look, there is a little box on the left-hand side, and it says estimated cost, right? Never leave broker's fee and the dollar amount blank, ever. As a listing agent, that's the worst thing you could do. We had one seller who showed us their seller's net sheet because they were saying the agent never told them blah, 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 all this. Because it's in the listing agreement as a percentage, but it's not put in a dollar amount. And sellers and buyers are just not very good about signing forms and saying, oh, here, let me pluck all these numbers out so I can make sense of what it's going to cost me to sell my property or to buy. Buyers have a great built-in resource if they're getting a loan because their lender is obligated by a fiduciary duty to go through that with a borrower. But in the case of a seller, don't ever leave that blank. That's a big thing because while they agreed to it in the listing agreement, man, it's going to make dollars and cents here for the list price so that they'll know. A lot of these you're going to see prorations, and it'll say prorated for so many days, or it's going to say wiring fees or all of these things. They're estimated costs. So there's not a certainty about it, but at least it gives the seller a pretty broad basis. We always want their estimated cost to be more, right, on the net sheet than it was in actuality. They always feel like they did better, and we'll feel better because if we underestimated something, they're going to jump all over it. In the little blanks below, what I used to do, it says repairs required by buyer, repairs required by lender, and these are estimated. And for a certain price level in properties, we're able to see from MLS what did the seller contribute to repair costs in those. So we have a great resource and a database that kind of gives us information. So we kind of develop these ranges that we can use in our listings that could do it. It also means the condition of the property, doesn't it? And as a listing agent, we may not be inspectors and we don't know what's hidden behind walls, but we certainly can see things that readily available might consider cause problems. Number one is wood rot. You and I are not up on a ladder looking with a microscope at what it appears to be wood rot. But I am going to tell you FHA doesn't like it. And every seller has to fix it. So there's been things under TRID regulations that will cause problems for a seller. If you look in the right-hand side, it says estimated proceeds to sellers, okay? So we're going to work off of a list price as a sales price, right? We want them to kind of know right today you can list your house, and this would be your estimated net. Now, it says less estimated cost, which comes from the left-hand side, and then it says less estimated loan payoff. What I want you to do is highlight that. If the sellers have given you a number, say per sellers, okay? And the reason for that is many times sellers will say, oh, it's such and such. Well, you're going to use your net sheet basis based upon what they told you. You don't have to independently investigate it. It's going to come out eventually, so you really want them to be certain about that because that could cause some problems. What I am going to ask you underneath there is if there was loan modification, okay? And the reason is we've had many, many issues where owners get into trouble sometimes, and so they have to do loan modification so that they won't lose their home and they abate foreclosure. Well, what they don't understand is they have two loans. It's not just added to the original loan. It's an actual standalone separate loan. And when we ask the seller about loan modifications, they're going to go, well, what is that? And you're going to say, well, that's when you and the lender got together if you've ever needed to modify your loan and they've given you another loan. And what happened is the listing agent didn't cover that. The sellers thought it was just all a part of that one loan, and it wasn't. It was a $40,000 separate loan. They could never have sold that property. And that poor buyer went through all the expenses, all their loan expenses, inspections and everything, and appraisal to get down to the end and find out that the seller never could have sold it for the list price. We have to do a much better job. We've got a lot of those loan modifications that have come in the past couple of years and has caused major problem. And sellers don't understand that. They think, oh no, it's all one loan. They've signed stuff. They just don't make the connection. When somebody has to go through a loan modification, they're usually distressed. We call short sales distressed sellers. And what that means is they don't understand it. They just want it to be over or get it resolved. You know what I'm saying? And so that's the problem. We have to be more exact to get to the bottom of it for them. And then again, it's an estimated net proceeds. I used to underline that and put little stars around it so that everybody knew and circle it that it was estimated. It says it at the top, but you know how some people are. They think, well, this is what it's going to be. So my gift to you is, as a listing agent, just make sure you have that for the list price with those kind of notations that I've added, because I want to make sure that at no time could a seller come back and say, you never told me. Okay, and that's the biggest issue that we have typically when we're talking about a net sheet. Again, they sign a document, a listing agreement, but they don't have any idea. They really don't. So don't make any assumptions that they do know that. All they have to do is initial at the bottom. Isn't that lovely? And then you have verification that they actually received it. When they receive these documents and they initial or they sign and date, they're charged with having read it. And you certainly will review it, because this is the critical part for a seller to say, yes, I can sign the listing agreement for this list price. In other words, that's that step that's going to verify that. Showing instructions. Well, the broker is mandated with having this listing, and if they have the listing, they better know how to access the property. And what that will be is sometimes if you have CSS showing instructions, you can upload those, or it could be that the agents have to be present. If you have to be present, you better give us the contact details for the sellers where they prefer to be contacted by phone in the event of an emergency. Believe it or not, we've had emergencies that have come up on properties. Sellers are out of town, so is the listing agent. And then somebody did it, and they contacted us and said, the police were there, there's a sign in the yard, do you have any contact details? Had we not had the showing instructions, the broker wouldn't have known who to best contact regarding that property. So they are obligated to know that, so you must give that. If you don't have CSS showing instructions, you need to put it on a separate page that says showing instructions, some way that we can see it and identify it pretty readily. The tax profile. Well, I am going to tell you that the tax profile usually gives us a little more confidence that the sellers in paragraph 1 of the listing agreement are the owners of record. What that means is that somewhere filed and recorded, they're saying they own the property. Okay. What does concern us is if we see a tax profile with Jane and John Doe, and Cindy and Bob are on the listing agreement, we're going to ask for why is this happening. So to save yourself some time, in the message section, you can say that the sellers just bought the property, 30 days ago or 45 days ago. They went in to rehab it or whatever, so that we understand the difference between the persons, owners of record that are filed and recorded versus what you have on the listing agreement. The tax profile also is very important for you to give to your sellers. You want your sellers to have everything that you can have printed out that's from MLS, all of these various things, right? And the reason for that is you don't want the sellers to think that the buyer's agent isn't going to do that for the buyer of their property. They are. But you want your sellers to have everything just like the buyer will be receiving. I'll say 15 years ago, I don't think buyer's agents did that. Normal and customary, do you know what I'm saying? They just didn't approach doing the data for a buyer the same way we did when we worked with sellers. Well, buyer's agents are very different today. They absolutely do that. They go through and get any detail and data that they have at their fingertips and give it to their buyers about the property. So you want to make sure your sellers at least have that same information. I always found it really important when you do the comparative market analysis. You know how you go through the comparables that you might have culled from the MLS data, and the sellers, oh, that property doesn't compare to mine at all. Yeah, and so you kind of get a little more insight into how they feel about their property. Most sellers, they look at their property through the tax man's eyes. So on the tax profile, they want very little value, right? Assessed value, because that means what? Very little taxes. But boy, when they go to sell the property, they want it to look like it's, much more elaborate. What's interesting is we had a seller who wanted to challenge their taxes and get them raised before they listed the property for sale. And because they felt that was it. I think Harris County is about, I think they're at least at 90% or better with assessed value. They had an 8% increase over 1 year's time. I think they were catching up with them. In my part of the world, we have about 95% to 98%. It just depends which year they get real aggressive on raising property taxes and that type of thing. So every locale is different, every appraisal district is different, but you know that after working with these properties, you realize that this property sold at 90% of its assessed value or more. So it's good to make sure that you pay attention to the MLS printout and have your sellers acknowledge it too. The biggest thing on the MLS printout that causes us problems would be what? Square footage. And it's really funny. The same square footage that's there the day you take the listing agreement is the exact same square footage on the day of closing and funding. But it's a number, isn't it? And there are different interpretations for those numbers. Every appraiser is different. We could have 30 of them go out and measure the same house, and not one of them would come up with the same number. Now, what I am going to warn you about is that I want you to at least address this with your sellers. If your sellers keep saying, oh no, the builder that I bought it from says it has 3,750 square feet. I'm just going to tell you that builders never had the real square footage of any property, okay? So right away, let them know that, because now they have to go hunt down maybe their appraisal. We had one that it was 600 square feet off from what the builder cited. And you know how they have the model number? And they usually incorporated, quote, their square footage. Well, somebody included the garage, and it was a 3-car garage and all that. And these poor sellers, these buyers, didn't have an agent at the time they bought it. That's what I asked the agent to go back and find out, because I kept thinking, yeah, they really wish they had. Because that's usually what we find out, is that when they get the appraisal back, we'll see a discrepancy or an issue. But those sellers had been paying taxes on something that was not heated and cooled for many, many years. And there's not a seller on earth that would pay for something like that. But buyers get real sensitive about it, because, see, when they go to see the house, they're looking at what is in the MLS or what's in that tax profile as gospel. Oh, it has this much square feet, and I'm going to tell you that is never the case. Even we've had one off 40 square feet, which I thought wasn't bad, right? And the buyer about imploded. And I thought, well, if they send another appraiser out, it'll probably come out 60 square feet over what they previously assessed the square footage. So again, it does cause us a lot of problems. So again, we want our sellers to kind of look at it. And if they did buy it from a builder, kind of get with them about that versus what might be in the tax profile. Now, here's some tips. I have the listing agreement memorized, and so I'm sure you do too. And so what we're going to do is we're going to talk about the elements in the listing agreement that you can never, ever skim over. It's going to be such that you probably have to really take the time to read it to your sellers because they've become a real headache for agents, and that's what we want to try and avoid. The first paragraph we're going to talk about will be paragraph 2, property. And the great part about it is if you read it with the sellers when you do the listing, it's the exact identical paragraph in our contract. So property is the same in the listing agreement as it is in the contract. So at least your sellers won't have to read it twice, right? Once you read it. And the reason you're going to need to read it with them is because we have things called improvements. The first part of that paragraph talks about the legal description and the address. The second paragraph talks about improvements, and it says those things that are permanently affixed to the property. That's considered real property. And I don't know about you, but that's why we have a license. We have a license to sell real property, right? Not the swing in the backyard, but real property. So what happens on that, the improvements, it says it's listed, these items, but that's not the entire item list. Anything that might be permanently attached to the property will convey with the property, okay? Unless the sellers do something else, and we'll talk about the last paragraph. Improvements, it talks about the mounts and brackets for the TVs. A few years ago, it wasn't in there, right? They didn't mount TVs. And then all of a sudden, now there were litigation and lawsuits over the buyer goes through their final walkthrough and they see big holes where the sellers took the mounts and the brackets as well as the non-real estate item, which is the TV. The TV could be unplugged, just like the refrigerator, washer, and dryer, and then scooted out the door. So when that happened and all those lawsuits came about, Trek was asked to include them so that it was very, very obvious, something common and standard in our industry, that it was included. I'm going to tell you, if a seller said they wanted to exclude something, which is a part of that paragraph too, as well, they better take care of it right away, or we're going to have to document it well, get everybody's signature and their understanding before they make an offer, okay? Because as a listing agent, that's what will cause you problems. Now, mirrors are the biggest issue that we've had problems with, okay? Mirrors that are permanently attached, and those are mirrors that are glued, right? Have y'all know what I'm talking about, like in bathrooms and other places. What we find most is in powder rooms or half baths. They're more like a picture frame. There's a mirror on a hook that just all you have to do is take it and the hooks remain because they're permanently screwed in, but the mirror goes, okay? And I can tell you as a buyer's agent, once the buyers decided they fell in love with this house, you had to kind of look at it very differently, like where are the landmines? Okay, we got a pot rack here in the kitchen. The pot rack was going to go with the sellers, but the actual hooks that the pot rack was attached to, they're going to stay in the ceiling because they're permanently screwed in. So there's lots of things you're going to pay attention to. The other thing we have a lot of problems with are these Wi-Fi security systems. You know, they look like little frames and all that. Yeah, and on the day of walkthrough, the buyers implode because it's gone. I am going to tell you, no seller can leave anything that has wires hanging out. We had one last week where the agent called and she said they removed the speakers and all that's remaining is the wire, okay? Well, if the wire was attached where they can unscrew it, the speakers go, right? But that's an issue that's always going to cause problems. So get that cleared up with your sellers at the time of listing so that it's clear what is going to be excluded that could be construed as being a part of the real property. Again, most of the time we have the issues on the last day when the buyers do their walkthrough, right? And something's missing. The next paragraph talks about accessories, and that gets a little more complicated. We had a situation where the sellers had a pool. And in the pool they had this device, I call them a little barracuda, that goes and is always wiggling and keeping the pool really clean and stuff, right? So on the day of walkthrough, the little barracuda's not there. And you're thinking, well, no, all pool accessories convey blah, blah, blah. Turns out the neighbor loaned it to the sellers. It was the neighbor's barracuda. Now, I don't know about you, but I don't know how you'd get a waterproof sign that says the barracuda is the neighbor's, not the seller's. You know what I'm saying? That was horribly misleading because you don't have something swimming around with pool accessories conveyed and then find out it was the neighbor's. Buyers don't become reasonable with stuff like this. Curtains. Oh, yes. We have problems with curtains, draperies, rods, and all this. I am going to tell you that the worst one was there was a little valance in the kitchen window. And the kitchen window couldn't have even been 3 feet wide, right? And there was a little valance. And the sellers were being moved by their relocation company. Now, I've been relocated a lot of times. And let me tell you, those people wrap up trash in one destination, and you get to unload it in the next one. I kept telling them, don't bring those snow shovels. We're not going to need them in Texas. What do you think I find in our moving van? All wrapped up real nice with brown, and you unwrap them like a present. There's the snow shovel. And so I know how they are. So here's what happened. When the listing agent got the hysterical call from the buyer's agent that the balance was missing on their walkthrough, the listing agent picks up the phone and calls the seller, and she says, oh, my gosh, I guess they put it in storage, but we won't see that storage for years. We're overseas. So then the buyers came back and they wanted $300 for that balance. $300. So the seller let us know that she thinks she spent maybe $7 or $8 at Walmart like 9 years ago for it. But the buyers insisted upon $300 for that balance. So you kind of see how now, I'm not to say it was worn and torn. It must have been adorable for the buyers to be so attached to it and think it's worth $300. But they became very unreasonable, and they wouldn't close. And those two agents, bless their hearts, they went together and gave gift cards for $300 so that buyer would close. It was horrible. So we do have, as I said, accessories and, yes?
We're getting a couple notifications that they can't hear you or see you.
Okay.
Because of your mic. If we could just move a little more in the middle. Like where the camera's at.
This is about as far as I'm going to go.
Okay. And if you could move your mic to your in the middle of the culture. Gotcha. Thank you.
Can you hear me? Okay. So again, paragraph 2 causes a lot of little issues, and they come up at the very, very end, typically. Now, the last paragraph in paragraph 2 is exclusions. This is where a seller gets to tell the listing agent and any prospective purchaser that while it may be construed a part of the property, real property, I'm taking it with me. For instance, in accessories, they talk about drapes and curtains. And if a seller wanted to take the bedroom curtains that match the bedspread, that would be the place that they would exclude them. Here's what happens to listing agents that don't have what I would call an exclusion list attached to the listing agreement and made a part of the contract. The listing agent had it in the listing agreement to exclude them. I don't even know if the listing agent put it in agent remarks. I can't remember that. But what happened was when they got the offer, the buyer wrote none. in exclusions because the listing agent didn't return the call of the buyer's agent. The buyer agent was asking about these things. Had sent an email and called the listing agent. The listing agent hadn't returned the call, and the buyer was afraid. They wanted to hurry up and make their offer, and get it in. So they wrote in none. And it was an oversight on the part of the listing agent to not go back to their listing agreement and see what was excluded and make sure that it was really provided to a buyer, a prospective buyer, prior to offer, because you don't want them to ever feel like they weren't told something. That's not a good position. So again, be very careful. We tend to get excited about offers, and we're doing a net sheet for the offer, but we don't usually go back to the listing agreement and kind of check everything. So if you're a listing agent, I would recommend that you create a listing an exclusion list for paragraph 2. That would be identifying maybe the source, the room, what it was, and then have parties being able to sign it and make it a part of the contract so that everybody would know what is excluded in the sale of that property. Yes? Hold on. You're going to have a microphone. Next thing, I'm going to make you come up here and stand right here next to me.
No, I don't mind.
Okay.
On the other side, I know of a couple of agents here in our office who did the reverse. They included appliances that normally do not convey, and they put it on MLS that they were included. And then the buyer's agent forgot to put a non-realty addendum to it. And
Yeah.
so the seller thought the buyer didn't want it. And
Well, the seller was right to think that. The buyer agent made a huge mistake.
absolutely, and so then the buyer's agent had to buy their client new
Right.
appliances.
Absolutely. One of my former partners,
Out of your commission.
yeah, well, one of my former partners sent over a non-realty item addendum with their offer. Unfortunately, when they got the offer back that was executed and it was a contract, she failed to make sure she had all of the addenda. And on the day of walkthrough, a 27-year-old refrigerator, washer, and dryer were given to Goodwill the day before. And she had to bring money to closing. She didn't have enough commission to pay for new appliances. No buyer would allow a Goodwill appliance after that. The buyers realized that the buyer agent had made a mistake in not making sure that it was a part of the contract. And so that's the thing. MLS doesn't convey. Listing agents will be nailed for what's ever in there. I can tell you that for a fact. So again, but it's not a part of the contract. It could be misrepresentation on the listing agent's part, but it's not a contract between a buyer and seller. And so that's where the listing agent would not have been psychic to know that the buyer wanted these appliances that are not part of real property. It's up to the buyer's agent to make sure they attach it to the contract. I am going to tell you that out of paragraph 2, it usually comes down to the agents having to make it good because they are very close to closing, and especially for agents that might have missed something or they failed to do it. I am going to tell you the biggest problem that we have is real property includes chandeliers, right? Anything permanently attached to the property. And we had an agent who had taken photographs, paid professional photographers to take wonderful photographs of this property. And in MLS, she had an exclusion list about all the chandeliers, but prospective buyers knew about it. Well, she had several transactions that the buyers bailed because the sellers wouldn't give them those chandeliers. You know how buyers are. Sellers said they're excluded, and buyers said, no, I want them, and if you don't give them to me, I'm not going to go forward. So finally, after all of these attempts, the sellers and the listing agent got together, and the listing agent just said, look, I think you just need to remove them now. It's just becoming too much of a problem. So the seller hired somebody that was not paid by invoice to remove the chandeliers. What the listing agent failed to do was have new photographs taken. And that is real property, and that is misrepresentation. And the seller was sued after the closing, not the listing agent, but the seller was sued by the buyers saying that these were a part of real property, you moved them on the day of closing, blah, 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 all this kind of stuff. What it turned out is the seller said, okay, well, I'm going to sue the listing agent. and make them pay for everything. And that's what happened, and it was deadly. Sure.
So if the photographs had the chandeliers, but then the buyers came to view the house and they were not there when they viewed it, would that still hold up?
Well, that was the case here. Those chandeliers were gone. But the buyer's agents wanted to make it a point and said, here, the listing agent made a big mistake. They still have them as photographs showing the real property.
Did the agent, the listing agent, excluded on the MLS? Can they still come after you if you are excluded them?
She had excluded them when they were attached. Once they were removed, there's no reason to exclude them. They're no longer there. Her biggest problem was she didn't get the photographs retaken. Yep. And so that was a horrible thing because that cost her big time. The seller was a doctor, and he wanted her to pay his lost wages from that day of $23,000 too. Because I had to sit in mediation with him from 8 o'clock in the morning until 7 o'clock at night. Yeah. Oh, baby, it was a typical. It wasn't purposeful that she didn't get the photographs retaken, but it was a misrepresentation. And because the photographs were still there, it was very hard for a seller to prove when they paid somebody under the table who left the country to take them down. You know, you didn't have anybody who could come in and say, hey, I took them down on July 7th, and you saw the property the first time on August 24th, that kind of thing. So the seller didn't help us at all, and they didn't care about helping us because they knew they were going to nail the listing agent for that. So just remember, the pictures in MLS, they better convey a true picture of what you're conveying. Now, typically, we don't worry about couches and sofas and chairs and bedrooms. We don't care about those because we all know what those are excluded. But real property is something permanently attached. That's why the chandeliers were a big thing. Yes?
What about a home that the owners leave and take the furniture after 2 or 3 months, and they leave, and you still have the pictures on MLS? Do you have to retake them?
You mean with their furnishings?
Without?
No. When they leave and take their furnishings, I don't think so. I don't think that would be an issue, especially if the property is vacant. But if they took something that was permanently attached, yes, that's what you'd want to do. That was the big thing. Yes?
You know, washer and dryers and refrigerators are non-real property that, you know, you have to exclude or convey, but because you can unplug and remove. But what about an electric stove or something? Or a dishwasher that's like
Anything that's built into cabinetry it's included. So a dishwasher that has counter on either side. The only time we've had a problem was a standalone stove with no counter on either side, and it was a Wolf stove. Does anybody know how much Wolf's cost? The listing agent had to pay for that. Because it wasn't excluded in the contract, and stove is a part of paragraph 2. So you have to be very careful, as I said, from a listing agent perspective. Take that time if there's going to be exclusion. I always like to tell the sellers, look, if you want it excluded, remove it now before we take the professional photographs. Nobody's going to have a problem with that. But again, as a listing agent. It's really based upon the cabinetry around it. If it's built in, it stays.
But if it's freestanding, but it's gas, so that's attached to the house.
Yeah, no, that can be tapped off, and they can take it because that stove can go somewhere else. So again, anything standalone like that that is a normal conveyance in paragraph 2, you want to have an exclusion for that. Otherwise, it's going to remain. Again, this is one paragraph you really do have to read with your sellers.
I'm sorry to interrupt again, but if this is in the listing, in the MLS, the pictures don't show because that's the situation I am in right now. They took very few pictures, like 5 pictures. It's a very cheap property, right? And I don't have pictures of stoves or dishwasher or anything. If they remove it, I have nothing to prove that they were there.
Right. And as I said, if it's not built in, that would have been something you probably want to put on a non-realty item addendum just to make sure that everybody understands they will convey. If it's built in, it has to remain.
So because I have that's past that, can I add this?
You can add a non-realty item addendum at any time to the contract with an amendment. That's how you do that. Okay. Paragraph, yes.
I have a question about timing. If somebody's seen the property, but they haven't made an offer yet, and then you put in a non-realty exclusion kind of thing, how do you handle it?
She was talking about an exclusion that the buyers may have seen the property and it was included and then it became an exclusion. Let me tell you, every buyer prior to offer needs to be provided the exclusion list by the listing agent. That just is a given. Don't tell them to download it because that's not delivering it. So, you know, you can say, please download the exclusion list and agent remarks prior to offer. If you have any questions, call, that kind of thing. But you as a listing agent would want to make sure before any offer was considered by anybody that they have that exclusion list in their possession so that they are aware these items are excluded. It'll go in the contract too, but you want that buyer prior to an offer to know what is excluded. That's the big thing. Yes?
If they include furniture as a bonus, decoration is part of furniture or is not?
No, decorations are not. Decorations can be, you know, removed and the real property stays the same. In furniture, we're not in the furniture business. I don't know about you, but I hate conveyance of anything that is not your typical appliances that might be included in a sale. I don't like furniture. It's a problem. And lenders definitely don't like it, especially if there's a dollar amount. If there's zero, it's, you know, an issue that it does need to be vetted with every lender prior to contract execution, just so all parties know, is it going to cause a problem or not. A lot of times these problems with non-realty occur when the lender finally looks at everything and then they say, oh, this can't convey, and now the buyers had their heart set on having these things and the buyer can't get them. Okay, so we have a lot of issues. It's not an issue for a seller. They get to make a decision independent of that, but most buyers that are financing are subject to what the lender will allow or approve. Paragraph 5, I highlighted it. It says broker's compensation. Why do you think I highlighted it? Because it's real important. I want you to get paid. The biggest issue that we have is that a lot of listing agents think it's just their listing commission, not the total commission, okay? And we had one seller who actually read, and the listing agent worked for free. Because it's the total compensation, just not one side. And the reason I want to really run that home is because I am so tired of listing agents having customers and they feel they have to justify that customer with representation, quote, in an intermediary relationship with no appointments so they can get everything in paragraph 5. Quit apologizing for it. It is all your compensation, period. The listing broker just says, oh, by the way, I have another paragraph. If I cooperate with another broker, I'll do it at this percentage or dollar amount. But make no mistake, that is all the listing broker's commission. So don't apologize for it. That's why I brought it out on the net sheet to make sure you don't miss that, because it is all the listing broker's compensation. We'll just cooperate in the event that the cooperating broker brings a procuring buyer. It is your commission. And I see more agents doing all of these flippity-gibbet things in their listing agreements. If I'm the only agent on a Tuesday, then it'll be this. Well, I hate that. I absolutely abhor it. Okay? So it's about representation. With a broker, if there's no appointments, nobody has any representation. Nobody can get opinions and advice. And pretty soon, Truck is going to say, we don't allow it at all. That's what I'm afraid of. Chuck Jacobus, who's one of the premier real estate attorneys in the country, he writes about it. You're going to put yourself out of business if you keep telling somebody else they don't need an agent. And the reason I'm really saying this is because I'm truthful about this. I believe everybody needs representation. I told you last month, attorneys don't even know how to count. We have the magic formula for knowing how to count for all days in the contract, all dates, right? We know how to do that. Not everybody knows how to do that. So we have a lot of issues because people don't know how to count. But as agents, we know how to count. So never undersell yourself and never give away a lot of things. I understand concessions, and that's fine, but I want you to make sure that number in that paragraph is the total commission that will be given, period, not just one side. Okay? We have lots of people who make mistakes on that. In paragraph 5, we've got lots of things. So it talks about when is it earned, when is it payable, when is your commission earned? At time of executed contract. You only get paid when? When it funds. We've had a lot of people last week who closed and nobody funded. So that's why I said funded. Funded is the operative word. People unfortunately can close and it never finalizes it. But upon funding is when you're paid. Okay? So again, be very, very careful about making sure you understand that you earn it because you brought the two parties together. There's a result is an executed contract. Yes? Yes, she said, if there's a bonus added in the commission, do we add that? Yes, that's usually another option. Right under that first paragraph, it'll give a percentage maybe, and then underneath it you can say $5,000 bonus to selling agent, okay? I am going to warn you, the moment you put it in MLS, it is given. The seller can't say, I'm not going to give it because I didn't get an offer I liked. It is done. It's almost like, give me the check now because I'm not going to tell the other broker they don't get it because their buyer didn't give the right offer. A seller has to understand that. That would be your obligation as a listing agent to do that. But paragraph 5E is about protection period. And this is what causes some problems for you, okay? If you have a listing that terminates early or is expired, you have the ability to tell the seller within 10 days in writing, it better be certified mail, return receipt requested, or delivered and acknowledged the delivery. You're going to say, these are the following parties I would like to protect for how many days are in that paragraph. Years ago, I used to see 365. Then we let them know that there is no protection if they're free to list with another broker. See, they can't owe two brokers commission. TAR created this in our listing agreement. These are our listing forms. Chuck could care less about our private agreements, but TAR put it in there because they wanted to protect the brokers from having sellers who would terminate a listing and go behind their back to the buyers that the listing agent and buyer agent brought, okay? So it had a kind of a narrow reason to even become a part of our listing agreement. And it says in there that you have to do some things within 10 days. You have to provide it in writing and all the protected parties. And again, it's for only those elements that would have a seller going behind the back of the brokers, okay? If they terminate early, we have a termination of listing form. Yes, we have a form for everything. Otherwise, you can't do it. That's the one good thing that I learned years ago. If there's not a form, we don't get to do it. But in the termination of listing, it says to the seller, because you terminated early, I'm going to provide a provision that says I'll get compensation. Okay? And that termination of listing is critical because you have the right to say I'm going to get commission if you sell it within so many days, and it has a date on there. My thing for you as a listing agent, if you are the second listing agent where the previous listing terminated, not expired, but terminated, you better get a copy of that. And the reason for that is twice this past year, for the first time ever, the first broker reared their head 2 days before closing and demanded commission per the termination of listing agreement. And the sellers had signed it, but they didn't read it. And so the listing agent was going to be cut out of all the commission because TAR's ruling on this says that the second agent was at fault. If you are the second agent, third agent to list the property and it previously terminated, you have to get the termination agreement in writing so that you can make sure that the sellers would never owe two brokers. It happened twice this year. It has never happened before. So I don't know if they're having a seminar somewhere and all the agents are going. The interesting part, these were smaller brokerages as well. Here's this really sad thing. The seller wound up having to settle with the first agent, but felt so upset that the second agent got the contract in 9 days, and the other agent had it 6 months. And the seller said, this is not fair that the listing agent would get no compensation. And so the seller had to pay 2 brokers to settle it. We were willing to step away because we had made a big boo-boo as a listing agent. We needed to really get that confirmation in writing. And the seller, we did have conversations with him. They said, oh, no, I signed it, but I didn't read it. And it was clear as day that the protection period was for X number of days, it was like several months, and the percentage that they would get paid if the seller sold the property. So again, in paragraph 5E, it states that if they're listed with another broker or they're required to pay compensation to another broker, you're not protected. So protection only means if they're not going to another broker. Otherwise, you don't have any protection. Once they're free to enter into agency with another broker, that's it. But if there's a termination of listing that has it, you as the second agent better make sure you get a copy of it, just so that the sellers know they will not owe commission to more than 2 brokers. Yes?
On the commission part, if we put on MLS that there is like 3% plus a bonus, or when the contract comes from the buyer agent, they don't put the percentage correctly, or they misput in the bonus, which one takes place?
Whatever you put in MLS prevails, and you better correct it as the listing agent and put it on page 9.
So MLS proceeds.
Absolutely. MLS is a unilateral offer. You don't get to modify it. You don't get to say, if you bring a full price offer, there can be no conditions to it. It is given. That's why I said you almost need to get it from the seller at that point in time if the seller is going to do it. They can remove it at some point, but you better be clear about the removal, the date of it. HAR does not keep track of that. That is not a field that they keep track of, and we've had problems on that. So just be careful about that. Yes?
I just want to say this, because I know there's some new agents in here. If you get a bonus, which is 3%, it all goes to Keller Williams, and your broker gets to split it the way you're supposed to be split. So don't get happy and say, oh, my broker gets 3% and you get the bonus. No, your broker gets every part of your commission till you cap.
Yeah, bonuses are a part of the commission. There's nothing separate
Absolutely.
in
So I
the
just thought I'd
transaction.
throw that out there
All
in
the
case
broker
it comes
earns
up.
all the
They got
commission.
a separate check.
Yeah, so they share with their agent according to their agreement. How many of you have been successful of ever getting a bonus?
Right here.
There you go.
Said bonus, and I was like,
Even the builder, with the builder, still, they will.
If it wasn't an MLS, the builder gets to play all sorts of crazy games. MLS is the only avenue that is a unilateral offer of compensation that cannot be modified except prior to offer. And that's the problem, is if you don't do the right things and have the right notice prior to offer, you can't go back to the buyer agent and say, oh, we've changed our mind. That's not how that works. And the listing agents, you're going to have to be pretty firm on this because you're going to be in charge. Your seller can say all the things they want, but bottom line is your seller's going to pay it. They're not going to say, well, I'll accept it if you go back to the other broker and tell them I'm not giving them. You're never going to do that. That is a violation of the Code of Ethics. So just remember, that's not your job. Your job is prior to offer, you might be able to negotiate and have the 2 brokers sign off in writing, but you are never, ever going to have a seller tell you to go back and try and diminish the compensation that you offer in MLS, okay? I'm not saying that agents don't do things a part of the transaction, but you're not going to play those games, and no seller gets to do that. The next paragraph is paragraph 6. And paragraph 6 is about the listing, and so the services that you're going to post the listing in. The first paragraph we normally always mark, and that says we're going to put it in MLS. How many days do you have to put it in MLS? 3 days. The form says 5, but that's a statewide form. Our individual boards determine the time frame, and if you don't have it in 72 hours, HAR said, I'm going to make you get your broker to sign a form and your seller saying why it didn't go into MLS within 72 hours. That's an HAR 300 form. And the reason HAR did this, I'm going to give you a little history on this. You remember when this all came in. NAR's attorneys had written, I'd call it an edict. We call them white papers when attorneys usually write an opinion on something, but this was really an edict. And it came down from NAR because they were very, very concerned about MLS, maintaining MLS and its rights for all the agents and realtors who participate. So what happened is the attorneys at NAR said, look, there won't be such thing as a quote pocket listing. That is a bad word, okay? And what we call them are non-MLS listings. And the reason for that is your broker and you have made a promise to the board that you will put every listing in MLS. That's your promise that you made. And the broker has to keep that promise. And so what happened when NAR came out with this thing about you need to do this, all the associations throughout the states, they incorporated in their documents language from these attorneys at NAR. And our listing agreement says, in paragraph 6, in the last one, it says, Mr. and Mrs. Seller, if you don't put this listing in MLS, you're an idiot. And so that's what they wrote. They had to have it in writing saying how crazy you are not to put it in MLS. Well, HAR wasn't that enthralled with what TAR did. So HAR came out with a mandatory form, and that's an exclusion that the sellers have of putting it in MLS. And it's under two bases. Paragraph B says, I'm going to put it in MLS, but not for so many days because I need to clean up the yard, paint, I need to do these things, okay? So paragraph B in 6 says, hey, I'm going to put it in MLS, just not right away for these reasons. HAR still requires the use of the form. The seller has to sign that form and say that the broker never brought it up first. That's the big thing HAR was going to nail everybody with. If the broker mentioned it first to the client about not putting it in MLS ever, they're going to be in violation. And that was part of the inside the loop, all that was going on. And let me tell you how it happened. You know these e-blasts you get about pocket listings? Uh-huh. Well, apparently they sent some to MLS at HAR. Somebody happened to be on one of the lists, and it went. And I think that's how HAR decided, well, we'll fix that wagon. We're going to come out with this form. And I am going to tell you, I just need you to understand for your sellers, because we have a lot of sellers who think they get to dictate what goes in MLS and what doesn't. If they choose never to put it in MLS, they have to sign that form. And they have to also know that HAR can come to you and your broker at any time and ask what that property is listed for, what it's sold for, all of the detail, even if it's non-MLS. So your seller's not getting away with something that they get to think that they get away with not publishing it. The agreement is that at any time, even if it's a non-MLS listing, they get to come and ask you, and you can't decline them. And that was their purposeful. They wanted to provide the integrity of the multiple listing system. And so that was how HAR did that. So again, if you use paragraph 6B or 6C, which says 6B says I'm going to put it in MLS just not for so many days, and 6C says I'm never going to put it in MLS. You must have the HAR 300 form done before those 72 hours lapse. Yes?
So I have a question. So you have the listing agreement and they sign it's dated, but you're not going to put it on MLS. When you put for preparation for showings 5 days, the listing date on MLS is the sign date. Is that right? So it'll show that it's been on, it's 5 days.
Correct.
Yeah.
Yeah, HAR has the right to ask you the commencement date on all listings, even though they may not have gone active into MLS until such a day. We've only had HAR come to us one time and demand to see the listing agreement. And I guess something came up. Somebody complained about it and wanted to see the true listing agreement. And they have a right to ask for that, okay, because we're required to have a listing agreement in order to put it in MLS. Mm-hmm. Yes, ma'am. Mm-hmm.
I'm just curious as to what circumstances would you not want to put your listing in MLS?
I have no idea. Now, the only time I've been privileged to that is when we've had people in witness protection programs and high-profile celebrities, of which I can't tell you who it is, but we all know the person. And so, you know, you're not allowed to. So that's a choice. Those are the only time. And the witness protection is pretty serious. We have that a lot more than most people would think, believe it or not. And so just remember, MLS in 3 days. Okay, paragraph 9, intermediary. We talked about a little bit of the issue about intermediary with the listing. Yes?
I have another question. I don't remember which paragraph it is, but it's like on how you pay non-MLS agents.
It's 8, paragraph 8. Mm-hmm.
Is it 8? I never know what are the consequences of checking one thing or another. Like I have no idea. I see a lot of them just not checked, only MLS people. I mean, is there a reason to check or not to check?
Well, I think she's asking about cooperation with other brokers and the percentage of it, as well as non-MLS agents. I think every seller needs to understand that you're very willing to allow access to the property by a non-MLS agent. But the sellers have the ultimate reasoning. They can say, yes, that's fine. You can do the compensation. I don't know where that came from. You can do the compensation however you and your sellers want to agree to it. You have to be present at all showings. You have to be present for every inspection. And so there's a lot of work that you would have to do as the listing agent if you have a non-MLS participant representing a buyer. So that's why you'll see sometimes varying percentages on that. As a non-MLS agent, you're not given any offer compensation. You have to get it in writing before the offer. Yes? Right. Well, and as I said, there's a lot of work that you have to do as a listing agent with a non-MLS participant, because they can never access the property without you being there, ever. Yeah. So that's a real, you know, you need to be cognizant of that, and your schedule might not be the greatest to be able to be subject to that. So you and the sellers, while I believe in cooperating with them, I don't think that they're entitled to the same cooperation level that we might put in MLS, but that's up to the agents and the sellers to understand all of that. In paragraph 9, intermediary, we do believe in representation here, and it doesn't mean that you're not going to get the sale. As a listing agent, you can have a customer. They haven't outlawed customers yet, but customers are always right. But intermediary is really done with appointments only. And that means there'll be 2 agents representing, one representing the seller that's agreed for the broker to become an intermediary, and one representing a buyer under a signed buyer-tenant agreement. So the broker really wants both parties to have representation and somebody that will continue on at a fiduciary level. The broker is the only one who becomes neutral. In other words, the broker is not going to favor the buyer over the seller. It doesn't mean that the broker is an idiot. And a lot of agents think that the broker can't make an opinion about the situation. And that's not true. The broker knows that they can't favor the seller over the buyer, but they certainly understand the use of the forms, the transaction that's there, the contract that the parties have. So it's not like the broker can't issue an opinion. It's just they won't favor the buyers over the sellers. And so, truthfully, we don't have a problem when there are 2 agents involved. I do want to caution you as a listing agent, you are not going to have any conversations with an agent that's under intermediary here in the halls, casual. I'd like it to be maintained like it would be if they were at Century 21 or Caldwell Banker or Remax. That'll protect you the best and not show collusion. The worst has been when buyers and sellers found out that the 2 agents were on the same team and they had the same transaction coordinator, and that coordinator had touched both. They got really bent out of shape. They didn't feel like they had somebody really representing only their interests. They kind of had been, it got a little muddled. So again, make sure it's real clean, and it's always very, very strictly held to, nothing casual. Just think of it, like I said, that they would be at Caldwell Banker and not here in the office with you. Paragraph 11 is broker's authority, and this is where we're going to look at our multiple offer addendum, the handout that we have. What happened in paragraph 11, the broker has stated some authority that they have in the transaction to the seller, right? And what they're saying in this one paragraph, they're talking about the authority for in the event that there are more than one offer on the property, what will the listing agent be obligated to present to the prospective buyers and their agents? And in the contract, in the listing agreement, it says that the seller can tell the listing agent to shop other offers to other parties giving terms. Well, we don't ever allow that. The reason we would never allow it is because you're always going to be in trouble if you let your seller tell you what to do. So we came out where, in response to inquiries from prospective buyers and other brokers, disclose whether the seller is considering more than one offer, provided that broker will not disclose the terms of any competing offers. We had agents who were very foolish. They told one agent, I have 3 at full price and I have 2 over list. Well, they just gave terms to some other agent. So again, just keep it simple. Just say you're in multiple offers. If your seller tells you, look, I need 2 days, I want everybody to have it in by Thursday, and then I'll make a decision Friday morning. You certainly can convey that to the other agents and let them know, but you must tell all of them that they're in a multiple offer situation. You can't just pick and choose. We've had a listing agent who had 9 offers and told 8 of them the same thing. And that one that they didn't tell filed a TREC and a TAR complaint. So, and it was an oversight. They were doing it because they were dealing with buyers that were represented by other agents, and this one individual happened to be representing themselves, and somehow there was just a little gap, and they fell through the crack. Nobody will feel they've been treated fairly when that happens to them. The one thing I do want you to understand is the process, and this is where the seller has to be told really very clearly the process in the event we have multiple offers. The seller has to know that all parties are going to be told only that they're in a multiple offer situation, any deadline. And so the buyers are then asked, would you like to reconsider your offer or present another offer? Okay. The other thing is the seller needs to understand that they cannot counter, even if it's verbal through the agents, they can't counter to a party and think they're free to accept another offer that comes in. The moment the seller says to you as the agent, tell them, I'll consider this if they do this and they do this, or this is the list, you know, the sales price, these kind of things. You are countering terms. You've no longer just told somebody they're in a multiple offer situation. Now you're countering terms to another party. Well, the minute you counter terms, that seller is not free to go with the next offer that comes to them. And that's a problem. A lot of listing agents misuse this. While it expedites it and gets it, you know, maybe on the fast pace, it does not leave that seller free to accept another offer. And you have to be clear with the sellers. If I counter, you're in it. Even 20 minutes from now, if you get an offer that's $20,000 more. Okay? So the seller has to understand they have to make a decision. Do you want to send the seller's invitation, which would leave you open to get another offer and go with it, or do you want to counter to one party? If they counter a party, they have to successfully withdraw their counter before the parties have accepted it in writing. And we've had issues where the listing agent has gone out there trying to withdraw the seller's previous counter, and the buyer's imploding and threatening to get a lawyer and all these other kinds of things. So it does put the seller in a very bad position unless they're willing to accept the consequences. Okay? In other words, I'm going to counter this offer because I don't have anything better. You know, and they have to be told by you how that process works. If you look at the seller's invitation to buyer to submit new offer. This form helps the seller be free, not counter, and be free to accept any offer that might come in. And the interesting part about it is when they send this to the respective parties, they're telling them clearly, not once, not twice, but 3 times, this is not an acceptance of your offer, this is not a counter. And that's the way your sellers will stay out of trouble. I'm going to tell you, Murphy's Law comes into play. You have a listing, hasn't sold for months, and then all of a sudden you get an offer. And then what happens? Then you get another offer. Then you get another offer. And so what happens on those kinds of things is your seller has to make the judgment call. Should we send sellers invitations to all of them and see if some come back with terms that would maybe be more favorable for you? Or do you want to tell all the rest of them goodbye and go to one? You know, these are hard decisions, and the seller needs to make them, but they need to make informed decisions. The sellers that say, go ahead and shop this offer and see if you can do it. We've had lots of agents, listing agents, who have not told the truth. There were no multiple offers. And how this has happened is the buyer got very upset that they didn't get it. And so they went and knocked on the door of the seller. Seller told them that they had never received any offer. And it was here in this office, this whole thing that transpired. And, you know, we can only do so much. We're not going to go up to the seller's house, are we? No, they're listed with another broker. We're definitely not interfering in that. And it's difficult to get the other party to provide evidence of presentation. HAR has a neat form on that. We are at... That's horrible. We're at the mercy of taking the word of the listing agent, aren't we? And so that's why it's real important that we never, ever do anything that's not truthful, because we are relying upon that. The other party is relying upon our truthfulness. A lot of buyers get upset when they don't win, you know, the contract or something like that, and won't let things go. We had a horrible Trek complaint here a few years ago, and it involved the listing agent that was in a multiple offer situation, and the buyers did not understand that the seller wasn't here, that the seller was in a different area, different time zones. You know, they were subject to response time. So I think if, with your seller's permission, I think you really need to convey this to the buyer's agents that, you know, the seller is not here. They will be making a decision, but it's going to be delayed or whatever. You know what I'm saying? Because no communication on your part as a listing agent will make the other party be happy at all, okay? I didn't say give out all of the secret codes. I just said inform them of the true condition so that their expectation level is not that they're going to answer by 3 o'clock today, that they might not answer until tomorrow at 3 o'clock or 2 days from now. So the seller's invitation is an awesome, awesome form. The more you use it, the less trouble you will be in as a listing agent on something like that. Yes? No, that's not true. Get that microphone so we can all hear you.
Okay. I had a client whose name was so long, it was like the same length of the alphabet. And every time we put in an offer, they said every time, 4 times, we got another offer. Please submit your best and highest offer. And it was becoming really quite repetitive. You know, it's one of those things that's really kind of hard to prove. And my clients, you know, after I did them the CMA, they didn't want to come back any higher. I ended up getting my client a new construction, and we closed on that one about a week or 2 later. My client kept checking those ones that told us to come back with the best and highest, and they were still on the market.
I know. And I think that's...
I'm sorry, my client said, you know, maybe we should change our job. She's an engineer, but she thought she could become a warmer. She said those listings was cold until I applied, and then all of a sudden they got hot. Maybe she should change.
Well, that's kind of how you feel. But again, we've had major complaints because of that. And that's when the agents are subject to the TREC complaints as well as TAR complaints. TAR has 2 fronts. They can get you on the violation of the Code of Ethics as well as other things. So just remember, it could be an ethical complaint, and it could be a violation of the Code of Ethics, but there can be other complaints that they'll have. So it just is one of those situations as a listing agent. It's unfortunate when we have to communicate to our buyers that it's still showing active, and yet they said all these things. It doesn't feel good, does it? It doesn't feel right. It feels like something is just not right, and I'm going to tell you, it isn't right. Yeah.
Are there sample like audits by TAR or HAR or anybody on these people? Is there any way of tracking?
No, there is no audit feature. Nobody, as I said, nobody does anything until a complaint is filed. And we've had a lot of buyers who have filed complaints. I know the seller of the property that came into this office, we represented the buyer. And when that seller found out that the listing agent hadn't told them about the offer, they came into this office and said, I still want to sell. They knew enough to come to us because they had fired their listing agent and their other broker and all these things, but they knew that they had a prospect through us. And so it's one of those situations that it is unfortunate, but as I said, the buyers they just didn't believe that the seller had responded. Yeah, and I hate it because it is one of those situations where we do take the other agent at their word. Yes, yes, sir.
Is there an expiration date on an offer from a buyer, or if there is no response from the seller, when do you decide to move on?
Well, I am going to tell you that any buyer that presents an offer, they should put a deadline in special provisions. Otherwise, if they want to stop and withdraw that offer, you have to, as the buyer's agent, say, the offer that we submitted on such and such date and time is hereby withdrawn. Yeah. We never leave the door open. Yeah. We always shut those doors. If we put in an offer and it's not accepted, you're going to withdraw it so that the seller, we had a seller who was in a multiple offer situation, accepted one, right? Well, those people terminated during their option period. So he went back to the agent and he said, hey, we got any more of those offers? And he signed a contract, and the agent, buyer agent, was notified, and they said, oh, no, we bought another property. They had to pay the option fee to terminate. See, anytime you have your signature out, it could happen, right? So just be aware, if your buyers present an offer and they decide not to go forward or want to withdraw it, or they're in a multiple offer situation and they weren't chosen, you need to withdraw that so that it's not on the table that a seller could say, oh, I can sign this and make this a contract. Yeah, there is no, believe it or not, there is no withdrawal form. You have to do it by email. Usually the way we communicate with that party and get a response, that's how. You won't do it verbally. It has to be in writing. It has to be date and time stamped so that you can show that it was by this date we withdrew it.
So the provisions we can put on there, how many hours or days we expect to have an answer? Like
Yeah,
12 hours?
the buyer can, she's asking about, in special provisions, the buyer requires a response by the seller no later than 5 p.m. November 30th. Okay, and at that point in time, I can tell you I've seen lots of that, and the parties usually exit out and then they reach an agreement. You know, the listing agent didn't read everything timely and didn't present the offer timely to the seller, and the seller got all upset. And as long as the buyer is willing to go forward and take that provision out, it's fine. But I think that would be a way to communicate to the other party, I need your response, otherwise I'm going to go on. You know, some people, time is of the essence for them to buy a house and be somewhere. Paragraph 12 is about seller's representation. It has several paragraphs at the end that are fill in the blank. And in paragraph E, it says that the seller says that I'm current on my mortgage and any other liens on the property, my taxes, my HOA fees. And if it's blank, shame on you as the listing agent. It can never be blank. I recommend that the sellers have a little box where they can fill in none if that's none, and then initial it. But that would be the only way to secure the listing agent having reviewed that paragraph. And it is very critical, because if the seller lies to you, you're not going to be pulled into a mess saying that, you know, the sellers lied to me. I didn't know. They told me they were current. I didn't know that they weren't current. because the other broker and the other party can really pull you in if you did not do that properly. The next paragraph says, are there any other judgments or liens on this property? And that's not about the mortgage. That's about IRS. Could be vendor, mechanic liens from the past. And so the seller has to be very truthful about anything that could encumbrance them conveying title to the prospective purchaser.
Now, they could be unaware, so can they, but I don't know.
There's nobody who's unaware. I'm sorry. Now, I am going to tell you, as a listing agent, I would always pay to have a property search done before I'd ever take a listing. Because what happened when I did that, early on when I went on a listing presentation, back when I first became licensed, we actually could take people at their word. No, they have to prove it now in writing. And I'm serious, because we did. We took their word. If they owed $170,000, they told us, we wrote down $170,000. If they were current, they were current. Well, what happened is I had this one situation, and lo and behold, they forgot that they had over $1 million IRS judgment. I don't know how you forget that. I wouldn't be sleeping. Do you know what I'm saying? So after that, I made sure that I always did a property search. And so I would ask the sellers at this point in the listing, and I'd have this property search that I printed out that the title company did for me. And I would hold it, and I said, is there anything you think could interfere when you try to sell this property, conveying title? And I would have the answers in my hand. And it was very effective, because then they usually came clean. They really thought we don't do our job. They thought, oh, they're never going to find out. So there's no reason for these two paragraphs in paragraph 12 to be blank. E and F can never be blank. I want you to put a fill in the blank for your sellers to fill it in, and then I want them to initial it. They'll initial at the bottom too, but I want them to initial. And they told us the truth, because if it turns out it's not the truth, they're pretty bad people. And we're not going to take the hit for them. Okay, that's what they have to understand.
So these kind of informations on debts and things like that that may affect conveyance, that doesn't come with commitment, does it?
Yes, it does.
Because
But a commitment is after contract. That's not when you want to find out. You want to find out at time of listing.
I'm thinking that I'm representing a buyer, and I got a commitment that I thought there was some information missing. I called title, and they say they don't have like the tax certificate, and so they sent me a commitment that's not complete, in my view. Is that something that happens, or is it the commitment should include all of this?
Or the commitment will include anything that they do a search for the property, and whatever comes up that's been filed and recorded will appear. We've had closings that closed, and then 2 days later a mechanic's lien went against the property, and then the new buyer was stuck with that mechanic's lien.
Because I called them, and it seems to me like it's incomplete.
Well,
And however, they have sent me a
it can happen, and the title company didn't, at the time of closing, nothing appeared. And then something happened after the closing. And of course, the buyers came to our lobby because they were all upset because they had this lien on the property. Well, if the title company didn't know, and it was filed and recorded after closing, we don't have a crystal ball. We don't know what happens in the future. The problem was, truthfully, this property was owned by a flipper. And I don't know about you, but I'm a fierce buyer agent. I would have in blood that all of the payments to any subcontractor has been paid in full, and I want proof, because you don't want these secret things popping up afterwards. No, title insurance does not cover something like that.
Okay, so what should I do?
Well, we'll talk about that later. I think I need to get through this listing presentation. Those are whole different issues on something like that. But as I said, anytime you have a flipper, somebody investor who's come into the property and done a whole lot of work, you want to make sure everything. As a listing agent, I would want to make sure everything was paid in full. You've paid all of your contractors, your subs, everything. You have permits all pulled. In other words, we want to make sure we're listing a good property. On paragraph 14, this is limitation of liability. The first paragraph talks about a seller, if they have a property that's vacant, they need to get in touch with their homeowner's insurance to let them know that it's vacant. We had a client who vacated the property, didn't notify their homeowner's insurance, and when a pipe broke and flooded the first floor, the sellers had no insurance coverage because it was vacant. So again, it's a pretty important paragraph. You can never modify this paragraph at all. Most sellers who read or have attorneys read it, they like to modify all this. They like to put more onus on the agent and broker to do certain things. We had one ridiculous one. He wanted the listing agent and broker to be responsible if any lights were not turned on or if something wasn't done, and that we would pay them and all this. And it was a new agent, and I contacted him. I said, this is not the listing. You're never going to take a listing with a seller like this because you would have to personally do that. Again, we don't want the seller to say, you're going to be liable, and neither do you. So that's why nobody can modify this paragraph ever. We've even had attorneys who were listing their property that marked it all up, and we told them we couldn't list their property. And we told them, the broker told them, the team, everybody told them, and finally we had to get our attorney to call them and tell them. And as we were telling them for the umpteenth gazillion time, and our own attorney told them that we didn't do that, he just got upset and came to the office and signed the listing agreement as we had it, rather than the way he wanted it. So, even lawyers, they know how legally they're going to be binding if they do this, and they just wanted to put the broker in the place of paying for everything if somebody did something to their property. Paragraph 21 is no fill in the blanks. It is notices, and it's right before the parties sign. And 21E says to the seller, secure all of your valuables, put away your firearms, prescription drugs. I want you to circle that, highlight it in yellow, and have them initial. I hate the issues where the listing agent gets a call and the sellers come home and say, oh, my expensive watch is missing. And we've had sellers who've done that. And they get you all wrapped up and trying to figure out who was the last one to see. You know what I'm saying? All that kind of stuff. So I want it done. We also have had a lot of sellers who had prescription drugs that have been stolen. Okay? So they're all secured. In other words, if they leave them out, we're not going to be responsible. Firearms are a huge thing because we've had some sellers who kind of had problems with securing the firearms. Well, you can't have any showings if firearms are there. And I'm going to tell you, as a buyer's agent, if you walk into a property and you see a firearm or drug paraphernalia on the dining room table, no joke, you are to get your buyers, you march back out to the car, you call the listing agent, and you let them know why your buyers and you did not go in that property. Please don't think you can just bypass it. We had one listing where this gentleman, he was an avid hunter, and he had an arsenal of weaponry. And he was a little offended that we put in our listing agreement that he had to promise to secure all weaponry in this closed, locked safe, out of way and out of view. Well, apparently, the listing agent calls me and she's frantic. She said that they just got a call from the buyer's agent, and they said that it was all out in plain view on the bed and everywhere in the closet, and the door was open, and contacted the seller, and the seller said, well, I got a call at the office, and I had to run to the office, and I was out hunting this morning, and I just didn't have time to put it all up. Well, when we told him he breached his listing agreement and now he owed us all the commission, after that, you have to have a real understanding that this is not negotiable. You don't take a listing if you are aware of it. I'm going to tell you, I've sold a house that had a safe room in it that I didn't know about until the day of closing. So the buyers didn't know either. And it was very well hidden. It was behind the builder built the home. And I didn't know. I was the listing agent. And it was a secret room that they went down into a lower area where it was a safe room. They did have weapons there and other things, I guess, to be in a safe room. But it was kind of one of those things. You don't know those things going in typically. You won't find those out sometimes until the very end because the people want to keep them safe and they don't want everybody to know about them. But those additional notices, it's real important that you circle that, you highlight it, you make them a little box to initial it because I want them to know that that's their job. I don't want them to call you and say, oh, my OxyContin prescription has gone missing. When we found out they didn't have one. So anyway, various things. There's just nothing you could tell me that I haven't heard or been through. I think the worst was as a listing agent, we would go on tour years ago, 20 years ago, we went on tour, right? And we'd all get in the caravan and go out and see all of our listings. And sometimes we had 9 or 10 houses, a lot of them. And I could still remember going into this one house, and the listing agent is there, and she said, oh, they have a teenage son, but, he works nights or whatever it was. I couldn't remember what. And the next thing you know, he comes out in the hallway, and he wasn't expecting anybody in the house. So he was not clothed. Try and back up and reverse from that and have a ton of realtors go run screaming from the house. There's just, it's a lot of different kinds of situations. And so again, we've had various people in the property that we didn't know they were in the property with their girlfriend. They were playing hooky from school and stuff like that. So again, just make sure that when you get through the showing instructions with the sellers, if there are any individuals that might be in the property, no minor children can ever be in the property with showings. None. Ever. I don't care any time, way, shape, or form. As buyer's agents, if you see a minor in a property unsupervised, you are to exit the same way as if you see any other of these things that are going on. The seller's disclosure, did you have a question?
I was just going to share a story. I walked into an appointment to show a home with my clients, and there was another agent in there with her buyer, but they were doing hockey golf stuff. She didn't have an appointment to be there. So the look on their face.
I bet.
Another agent.
Uh-huh. Well, see, they were really showing the property. Lordy, yes.
No, I'm saying, I was always told to always ring the doorbell or knock. It doesn't matter if it's vacant or we have
Knock, you scream, you say, Keller Williams, Keller Williams. Right, yeah. You always do that type of thing. But some people might not have heard that if they were upstairs and doing other things that they wouldn't have been hearing. On the sellers, yes?
Sorry to interrupt you. Pets, if it is not included in the showing instructions, pets, a cat walking around this happening. I just,
Yes, as a listing agent, I don't know. I love animals, so don't get this wrong. But you don't want the animals to be able to be free range in the property. They need to be secured in some kind of carrier or container because, I don't know, it's disastrous when you're a buyer's agent, you open a door and the cats run in. Okay, well, here's what happened. We had a buyer agent, and her buyers went outside on the patio, covered patio, and they were looking, and the next thing you know, a cat goes running into the house, and so the buyer agent made sure the cat was in the house, locked it all up. It wasn't their cat. And the cat did a lot of damage. Well, then they blamed the buyer agent for allowing a cat into the property. And I'm going to tell you, I had Weimaraners, so they're not small dogs, and so they'd always be in their condo in a crate. Or better yet, I put them in my little Volvo station wagon, and we would go sit out in the cold across the street down the way, waiting till those people left the house. I mean, there was just things, you just didn't want them to be interfered because you never knew how the animal would respond. My dog would just bark until everybody wanted to shoot her. And so, because she likes people to pet her and touch her, and she was just a nuisance. But there are concerns if you have a listing where there could be free-range animals. You really want to make sure that they're all secured. We have several appraisers in this town that have been bitten by dogs. They will not appraise a property that has a dog. And I can understand. They've been bitten several times. So just to make sure, just go through all of that with your sellers and make sure, as a buyer's agent, you know, if you see an animal in the property that you were not notified through CSS, CSS should have, you know, dog is in the kennel in the kitchen and the cat is in the kennel in the garage, whatever it is. They should tell you where the placement is of the animals so that you don't feel that you're going to have them running. Because nothing's worse than trying to hunt down some animal, much less bring an animal into a property that doesn't belong there. But that cat thought it belonged there. It ran right into the house, just like it had been there. So those are problematic. Now, on the seller's disclosure, as of 9/1/2017, our governor signed into law last June that those properties near a military noise zone disclosure was required. And it's interesting. Most of our disclosures are about the property, not what surrounds the property. But this noise level issue is a big issue. Now, most of you don't have to worry about your properties. I live in Military Town, USA, outside of San Antonio. And not even 2 miles as the crow flies from my house is one of the largest Camp Stanley. It's a demolition. And when they blow off those things, my windows rattle. So it was meant for those kinds of things, for properties owners to understand what it can do to their property. And again, it was just a notice. My thing was, after Hurricane Harvey, no seller could use an old seller's disclosure. It needed to be as of 9/1, after that hurricane. Even if nothing happened to their property, that is what needed to be done. Yes?
When you're selling when you're listing a property that is in the path of the airport, like within a mile where the planes are so low you can actually read what it is that something that you need to disclose, or do they realize they're that close to the airport?
You know what? As a seller, I would disclose it.
That's what I thought you would say.
Yeah, personally, it's a material fact.
All right.
While the buyers should know that, but they might not, I would disclose it. As a seller, I would disclose everything and then some, because it's too litigious, and if you missed one thing, it would be very problematic. What I am going to tell you is that I'm just going to, well, we don't complete the seller's disclosure, and it's better for them to have a huge arm's length as a listing agent. I am going to tell you some things are disturbing what I see on the disclosures, and I just wanted you to know. When you see normal settling, no seller could write that. The only way they could ever be done is by a structural engineer. No seller could ever say, oh, this is normal settling, these cracks and that. There just isn't. And why the the sellers are trying to tell the buyer, oh, there's nothing for you to worry about. That's the worst on earth if there is something for them to worry about, right? So there are just some things that are just signals that give me concern. The fact that I see all these perfect houses, because we look at your seller's disclosures, and they're all perfect houses, and then I see a 67-page inspection in the contract side, that there's an imbalance. And I am going to tell you, years ago, when we had a property that had a foundation issue, we could never sell it. There would be no lender who would ever loan money on it. So it was always cash, and at much greater reduction than what the seller might find value in. And things have changed since then. They've got technology, they have transferable warranties and other things. So again, the disclosure really needs to be completed with you not around. But I'm going to make sure that you know that you are obligated to make sure there are no blanks. Every box must be marked. And they're not going to get the answer from you. You're not the source of anything on their seller's disclosure. If they use Seller Shield, they have created these wonderful wizards. And these wizards give legal advice to sellers about how to complete the seller's disclosure. The TAR form, they have to have your license number. They verify that you're a realtor with TAR. They allow them to complete the 1406. And they cannot finish until everything is marked. It's the most wonderful wizards that I've ever seen to be able to use. And the greatest part is it separates you. It sends you a completed form, all printed out, that we can actually read, because they can't do any signatory type things. They do everything digitally. So it's all typed. If they're explaining water penetration or previous flooding or previous fires, it's all very clean and neat, and it's legible. So that's the best way for your sellers. If they're really struggling, you're going to tell them, you know, you need to sign up for this service because you need more help than what I can give you. This is not my disclosure, it's your disclosure. And they're very good about pointing out the elements that have been all litigation issues. Yes? They have to go online. It's www.sellershield.com, and it's $199 if they buy it then. I think it's $299 if they buy it at closing and funding.
Well, the thing is, like, you lose it if you don't close, right?
Oh, yeah. It's
Well, but you pay you get the discount, but you lose the money if you pay less and you pay for it. There's something like that.
right. Once you pay for it, it's done. They're not going to reimburse you. The 1406 is the one form that we require. It satisfies all of the statutory requirements, and then it adds all of the litigated issues that have caused sellers in the state of Texas problems. They're very responsive. TAR is about litigation that goes on. They poll us every year, and they ask us what kind of litigation we have in our operations, and then we tell them. And then usually I tell them, fix this. I'm so tired of us having this problem. I want it out of the contracts and this type of thing. That's where you get your feedback. You get to give them good feedback on something like that. They also need to know, the sellers need to know, that in the event any material change in the property occurs, say they're under contract. We've had so many issues this past year. They're under contract with the buyers. Buyers have done their inspection. And then the sellers went to turn the heat on, because we had 2 days where it actually got, a little cool. They turned the heat on, heat wouldn't come on. But they went to closing and funding. They never told the listing agent, they never told the buyers that the heating didn't work. Now at the time of inspection, the heating did work per the truck inspector. But the seller knew it was no longer working, and they did not disclose. So see, there's a lot of issues, because at the time of contract, that property is considered to be as is based on what the buyer knows. In other words, the buyer has to know everything the seller knows about the property. Can't hide something. So a seller who conceals something like that is going to be in serious trouble. And I just don't like them pulling you into it as well, because that's never a good thing for the listing agent. The multiple offer process, we talked about it. We looked at the addendum. I am going to tell you that that's probably for a seller who wants to be open to accept another offer, and I'm going to tell you they always come in at way over what they have in their hand in trying to negotiate. But a seller needs to make that decision, and when you visit with the seller regarding that, do you want me to counter them, or do you want to send them an invitation? You better put it in writing so that it can prove that you had that conversation and that the seller made the decision. And you better tell them, look, if you ask me to counter and you get another offer in 2 hours later for a lot more, you can't accept that offer until you have successfully withdrawn your counter to this other buyer. Okay, so that's how the process will work. Earnest money disputes. Your sellers need to know that no earnest money dispute will ever be automatic. A lot of sellers think, well, I get the money. Well, they may be entitled to demand the earnest money because maybe the buyer didn't perform or they were in default. But your seller's never going to get it until both parties mutually agree to a release. It can't just be, well, I'm entitled to it, I should get it. And that's a wonderful world, but we don't live in that world. And in our contracts, it does say that the escrow agent, the title company, is able to say, if we give notice to one party and the other party doesn't respond within so many days, the title company may release earnest money. The word is may. It doesn't say will or shall. Okay? It's up to the title company, and no title company will release earnest money without the parties mutually agreeing to it. Yes?
If it is special provision, the offer comes at non-refundable earnest money.
There is no such thing. There is no such thing. Earnest money is handled contractually per the contract, and not one word ever says non-refundable. Nope, there's no such thing. As I said, only lawyers could write that, and the lawyer would have to be on the contract showing that they had provided that language. And then the seller, if they got that offer, they'd have to probably hire an attorney to interpret whatever was added by the attorney representing the buyers. But no agent can ever write that. There is no such thing. Earnest money is handled per the contract. I am going to tell you that when we've had disputes on earnest money, and the worst part is the seller is saying, you mean I have to go hire an attorney to try and get $500 back or $1,000? Why can't you get it back? That's not our job. So that's what I want you to tell the sellers before they even get a contract, that there are some things we don't do. We're not a legal firm, okay? So there might be issues that they have to hire an attorney to try and get it. Every agent who's ever recommended their sellers hire an attorney, they've done it, and that money has been released by the 5 o'clock that day. That's all it took was one letter. And they send it by email now, so everybody gets it really quick. They may send it later by certified mail registered, but it's at that point in time they send that email over, and it's amazing how many fast results we get on that. Now about hijacked listings. Here's what happens. They usually take your listings for sale and make them for lease. And then they instruct that prospective tenant to wire monies for the security deposit and first month's rent. And they usually benignly say, just go up on the back door, it's open, or the key's under the mat. You know, something that's lulling these poor tenants into giving this money thinking they have a lease. And then the sellers have somebody, we had a seller who had a shotgun when the buyers or tenants tried to enter the house from the back door. Just like the agent, quote, agent said, the seller's back door is open always, and they'll just leave it open and the keys will be in the kitchen counter or something like that. So, and we've had one here where they brought their little moving van, the tenants did, and they blocked the driveway and tried to move in their things to a house that was for sale. And unfortunately, the husband was out of town and the wife was there alone with her children and freaked out because these tenants said, no, I've leased this property. So every day you're going to tell your sellers, they're going to Google their property and see what comes up. The moment something comes up that it's not your listing or another broker who's given Keller Williams credit for the listing, they're going to contact you so that you can contact the authorities and let them know to take it down. It doesn't happen quickly. It can be a couple of days before those listings are posted or removed. But the sellers need to be a part of that to try and help you, because otherwise you'd be going crazy every day before you go to bed to try and find, you know, who's gotten into the property or is somebody hijacked my listing. So again, it is still happening, and it does it periodically. Like every 4 or 5 months we'll get it, and we'll have like a ton of them. I'll get them from everybody around, and then it'll be a lull, and it won't. But at this time of year, we get a lot of them. Okay, so just remember that the sellers need to be told to make sure that they contact and do their Googling to find out about how their listing is posted. And if it's not for sale by you or another broker giving Keller Williams credit for your listing for sale, that they're going to let you know that immediately. Okay, next month, which is just around the corner, TREC has a new ruling about advertising. And I am going to tell you, I've been a license holder a long time, and I am scared to death for you. The reason I'm scared for you is if you don't have everything done perfectly on your websites, on all your advertising, on your emails, the bottom of your email, all of this, on your postings, on social media, and that, you will be in trouble, and they will never forgive you. There's not going to be, you'll get another chance. TREC's reasoning for this is purely, the way that they changed it was so that they can come after you. So they're going to have people looking at your websites, all of your social media, and make sure that you have the IABS and the Consumer Protection Notice, it's in the right pitch, and all these types of things. So next month we're going to go through that. Nicole Joyce and her former group UpTech has training that's available on it. They assist you in making sure you are compliant. And as I said, I'm really scared. For new agents, it's not going to be as much of a problem because you're doing everything right from the beginning. You're getting guidance and all these things. What I worry about is agents who've been in the business a while, and some of the social media postings that we have seen would be enough to scare you to death, to think agents post things like that. And so my concern is that Trek is just not going to be very kind about any of this. I don't think they're going to give forgiveness. Trek, you have to understand, they're more of a consumer protection bureau than they're not your friend. They're a licensing organization, make no mistake. The attorneys that I visit with, one of them is on the Broker Lawyer Committee and another one who has championed a lot of Keller Williams offices in front of Trek. Trek has the thing about if they say, hey, if I tell you all the answers to this, then we'll never catch you. And so instead of providing us a framework or a guide that's a little bit more useful, in other words, we can look at it, now you know that you can never use your name except ending with team or group. We know that. It doesn't matter what you did before, it's all going to change. It's effective now. And so whatever, they don't grandfather you in. So all of your advertising, if you were using names that were not proper or whatever, you're not going to get a second chance. It's going to, it rolls out, it rolls out. There's 20 days from the time they all sign it, and they'll sign it sometime this month, they think. So again, my biggest concern is you need to be aware of this. You need to get in touch with, if you can't do it and you don't know how to do it, you need to get with somebody who can help you, because I just don't want you to be blindsided. And as I said, this has been, it's just the first time in their history that they're going after you without a complaint. Yes?
When you say get with somebody who can help you in this office, who would that be?
Well, I know Uptech sent out an email. In this office, I don't know who could help you with that. Who helps with that? The technology part of it, helping you set it all? Okay. Oscar who? As I said, you have to make sure that somebody has assisted you on something like that.
Just a question, I'm really curious now about these ideas with social media. Most of us have Facebook page, business page. Then we need to provide there as well the link for
Yeah, it's supposed to be in favorites. It's going to be the first things that come up.
Okay.
Yeah, when they click on favorites. Trek, a few months ago when I had introduced this, when Trek had told us they were changing it and they had posted what it's going to look like, they gave us their information about it. The one good thing, you know, when it says Texas Real Estate Commission, you know how long that was on one of these tabs? They're going to let us put Trek, but it has to be 12 pitch. Can't be small. It has to be a certain pitch. And when that word pitch is there, only graphic designers can tell you if they meet that. You and I could look at it and say, well, it looks right, but I wouldn't know for certain. And that would be your way. It does. And they want a real clear Trek. If it's a tab in Trek, when you click on that tab, those two images, your completed information about brokerage services and the consumer protection notice will pop up. So next month we're going to go through that just so that everybody understands what that advertising rules, because there's a lot more to it than just about your websites and your social media. It's about what you are required to do as far as advertising. All right, good people, have a good one.
Thank you. So next month,
It's the 18th at 9 o'clock.